Good evening and welcome. We're here, as you know, at Tillar House at the American Society of International Law on a lovely summer afternoon. And thank you for foregoing the pleasures of a lovely day in Washington in the summer to join us for what should be a very interesting discussion on the issue of cybersecurity and international law with our two distinguished guests today. Before I introduce Dr. Marja Lehto, Ambassador Lehto, which I'll do in a little bit more detail in a moment, and Sean Murphy, and they're known to a number of you in the audience, I first want to say a special thanks to Rina Rikaheka, the Counselor for Political Affairs at the Embassy of Finland here, who has been an integral part of the society during her tenure here and will be returning, as I understand it, to Finland very soon. But thank you very much for all you've done for the society and for helping us with this event today. So let me now turn to introduce our discussants. Ambassador Lehto is currently not only an ambassador, but a senior expert at the legal service of the Ministry of Foreign Affairs of Finland. She's held a number of interesting and important positions in her career, including service as Finland's ambassador to Luxembourg for a number of years, as the director of the Unit for Public International Law of the Ministry of Foreign Affairs, as the legal advisor to the Finnish mission to the United Nations in New York, to chairing the Council of Europe Expert Committee on Terrorism, CODEXTER, and currently chairing the executive board of a very interesting intergovernmental organization called Justice Rapid Response, which some of you may be familiar with, which provides technical support from a number of countries to the ICC. She's also just finished working on a UN group of governments on issues of peace and security. That's not the full title of this group because it's a much longer title, but we've compressed it by mutual agreement, and that's very relevant, very relevant to the topic that we're going to be discussing today. And she's been deeply involved, and this is reflected in her publications, in the negotiations of a number of international treaties and conventions on international criminal law topics, international criminal tribunals, including the Rome Statute of the International Criminal Court, the International Convention on the Suppression of Terrorist Bombings, the International Convention on the Suppression of Terrorist Financing, and the Council of Europe Convention on the Prevention of Terrorism. She also is currently Finland's national focal point for the responsibility to protect, R2P. She has become, as of last year, a member of the United Nations International Law Commission, and in that capacity is serving with our other discussant today, Sean Murphy. And I know we have several distinguished members of the commission in the audience, and we welcome you and look forward to having you participate today as well. Ambassador Lehto holds a PhD in international law from the University of Lapland and a master's degree in political science from the University of Helsinki. I will not take you through all of her publications, which are numerous, but she lives the interdisciplinary character of the society, and she's accompanied today by her husband, Lauri Sittonen, whom we welcome, who's also in the political science field. So we're delighted to have Ambassador Marja Lehto with us today. Joining her at the table, as you can see, is our own Professor Sean Murphy. Sean needs no introduction to many of you in this group, but I'm going to give you one. In any event, he is the Patricia Roberts Harris Research Professor of Law at the George Washington University School of Law, and some of his colleagues from the law school are here in the audience as well. Prior to joining the law school faculty in 1988, he served as legal counselor at the U.S. Embassy in The Hague, and represented the U.S. government in matters before the International Criminal Tribunal for the former Yugoslavia. He also served as the U.S. agent to the Iran-U.S. Claims Tribunal, and earlier served in the U.S. State Department Office of the Legal Advisor, advising on matters relating to oceans and international environmental law, international claims, and international humanitarian law. He has published extensively on a number of areas of international law, including environmental liability and many other topics. And in 2016, he was elected by the UN General Assembly to serve a second term as a member of the United Nations International Law Commission, where he serves currently as the Special Rapporteur for Crimes Against Humanity. In the Society, he is our president-elect. I'm delighted to say. He's also served on the Board of Editors of the American Journal of International Law and in a number of other positions. So thank you both for devoting the time to this topic today. We are looking forward to the discussion, and without further ado, let me turn it over to Sean Murphy.
Well, thank you very much, Lucinda, for that very warm and welcoming introduction. On behalf of both Ambassador Lehto and myself, we're delighted that you're here today and able to start us off. This is going to be a conversation between myself and the ambassador, but I thought I would set the table a little bit as to the subject matter that we're addressing. As Lucinda indicated, there's a group of experts that has been formed by the General Assembly and has had a few different iterations, but there's currently a group that was formed for 2016 and 2017. And it does have a long title, but I'm going to go ahead and give it to you. Group of Governmental Experts, and sometimes that's shortened to GGE. Group of Governmental Experts in the field of information and communication technologies. Sometimes that might be referred to as cyberspace, in the context of international peace and security. So that's this group that's been formed. They have a mandate from the General Assembly to study with a view to promoting common understandings and existing and potential threats from these information technologies. And so that includes looking at the way in which international law applies in this context, looking at things like confidence building, and trying to figure out capacity building as well for countries around the world. So we're interested in the information and communication technologies that might lead to threats of one kind or another, how it is international law might relate to them, and so on. The current group is 25 legal experts. Ambassador Lehto is one of the 25. They come from all the different regional groups of the UN. So there's a group coming from Africa, a group from Asia, a group from Western Europe and North America, and so on. So it's an attempt to bring together a body of governmental experts broadly representative of the global community. No doubt they break out into different groups in terms of their own approach to these issues, and it might be interesting to hear a bit about that. But the group that met for this past couple of years had a meeting this past week in New York. And as of Friday evening, there was two possibilities. One would be they might produce a report like prior groups that had been formed that had produced reports. So there's a 2015 report, 2013 report, I think, and so on. Or the other possibility is they could not reach a consensus on the differing views that they had about how to deal with this area. And as I understand it, they did not reach a consensus report. So my first question to you, Ambassador Lehto, or I can say Marja, why? Why did the GGE fail to reach consensus on a report.
Thank you, Sean. And before responding to your question, let me very briefly thank Ms. Law for the very kind introduction, and the American Society for International Law for the invitation to come to Washington, D.C. It's really a great honor to address such an impressive audience. And it's particularly a particular pleasure to be here with you, Sean. So on GTE, it was, as you said, the 5th such group in a row. We had a mandate for 1 year to study these different issues. But in fact, this time, international law, application of international law to the use of ICTs, basically the state use of ICTs, cybersecurity, was the most central and the most controversial issue, and the main reason why the group didn't reach a consensus on Friday evening. And to give you a little bit of a background, the most important achievement of the GTE process from 2004 in this respect has been that the 2013 report recognized that international law applies in cyberspace. A very basic recognition, but it was the first time it was done by state representatives at the UN. And it was considered as a major breakthrough. It has nevertheless been quite difficult later on to present more specific findings on the applicability of international law to cyber activities. And in 2015, actually, the group turned to producing soft law in the form of non-binding recommendations of responsible state behavior. The 2015 report also included some veiled references to self-defense, saying that the UN Charter applies in its entirety, and it also mentioned the inherent right of states in accordance with the Charter. It also contained a similar veiled reference to international humanitarian law, listing the principles of distinction, humanity, necessity, and proportionality. I take this was an example of what is often called constructive ambiguity at the UN, but it's not a very satisfactory way to deal with international law. If I take just one example, for instance, the principles of proportionality and necessity, of course, appear in different areas of international law and have different meaning and content in those different areas. So what we tried this time was to go further and include some explicit references to the law of self-defense, to countermeasures, and to international humanitarian law. And this was not possible. In fact, it seemed that some states wanted to reopen the consensus of 2015, maybe even that of 2013. And that's where we are.
So you got to a point in the prior report of saying that there were certain aspects of international law that were relevant, sovereign equality, sovereignty, settlement of disputes by peaceful means, non-intervention in internal affairs, and as you say, use of force issues. So you could identify the issues, but when you tried now to drill down deeper as to how exactly international law in those areas applies with respect to particular types of actions in cyberspace, it resulted in conflicts. Can you tell us a bit about what those conflicts were exactly? What aspects of international law really are so contentious that you couldn't reach a consensus?
The main issue that remained contentious was, let's put it so that all issues related to cyber war have remained very contentious. And the group, of course, because it deals with these issues in the context of international peace and security. It doesn't pay much attention to peacetime law. It's mainly the issue of threat of a use of force or use of force and armed conflict. But those have remained very controversial. And there's a certain paradox. While the group deals with, according to its mandate, dealt with threats to international peace and security, all these concepts remained a kind of taboo. There were certain countries that did not wish to mention them explicitly. For instance, this was the argument that if you mention IHL, that could somehow trigger an international armed conflict, make it more likely, or at least it would implicitly legitimize armed conflict. And this, in spite of the fact that ICTs are already being used in armed conflict, and it would be in everybody's interest that they are used consistently with international humanitarian law. This is one example.
So let's say you took the armed conflict issue off the table. Let's say you tried to do that. It seems there's still a lot of issues that you could be addressing. So let's say, in theory, a government transmits a malicious software to a country that it believes is engaged in a nuclear enrichment program for the purpose of developing a weapon. And that malicious software spins the centrifuges in a way that results in severe damage. Is that viewed as an armed conflict scenario, or is that not an armed conflict scenario, in which case is it possible to talk about how international law applies to an event like that? Just in theory, of course.
So what has to be made clear is that the group did not deal with these issues from a very legal point of view. It was mainly fighting on the applicability in principle. But then it did some very good work in 2015, tried to deepen that in 2017 on, for instance, proliferation of malicious ICT tools and techniques. Mm-hmm. But that was done in the way of soft law, or presenting non-binding recommendations to mm-hmm. states.
Mm-hmm. Right. Well, let me try another hypothetical on you. So let's set aside armed conflict and maybe even set aside what might be argued as a form of self-defense or something like that. What about if a government were to use cyberspace for the purpose of trying to manipulate an election result in another country? Again, go with me on this, because, is that something that falls within the realm of what it is you're trying to do? And does that present flashpoints as well that make it difficult to reach consensus?
Actually, yes. One of the smaller bones of contentions was related to whether we could mention interference in the political processes of other states, state interference in the political processes of other states. And of course, this is an issue that may have different legal, we may give different legal interpretations to such activity depending on the circumstances. But yes, that was mentioned and that was disputed. Mm-hmm. And
disputed that international law is settled in terms of precluding?
Or actually whether we should mention that as something that states shouldn't do.
Mm-hmm. Mm-hmm. Okay. Okay. So let me try one more hypothetical on you. I'm trying to tease out a little bit the issues that are here that I imagine are ones that at least people are thinking about as they work through this. What about sort of the general area of spying by governments on each other? Now with cyberspace, there are ways of using that technology to engage in surveillance, stealing files, and so on. Some people think that international law doesn't really speak to that field of spying, that it's sort of off to the side and to a certain extent has been tolerated and is outside the scope of what international law deals with, unless there's a particular treaty, maybe a Vienna Convention on Diplomatic Relations that talks about the sanctity of embassies and so on. Is that an issue that has come up in the course of discussions that has also made it difficult to reach consensus, or is that not really something that you've been discussing?
It has actually been seen as something that falls beyond the mandate of the group, so that it has been mentioned but not really discussed. The main issues, as I said, and those that were really difficult this time were the legal concept were self-defense, countermeasures, and international humanitarian law. And one argument that maybe should be mentioned was related to the capacity, different capacities of states. It was maintained that those responses, countermeasures especially, would only be available to a handful of states that have advanced technology and the ability to make the attribution and to respond by using ICTs.
Although isn't that true generally speaking when we talk about countermeasures, that some states are better equipped to do it than others, but that doesn't negate the law.
Exactly.
Right? Yeah. Okay. So where are we going from here on this? You couldn't reach consensus on the application of international law in the specifics to this field. What are our options? Is it keep the group going to try to, or a successor group to try to do more? Is it we should be thinking about a treaty in this area, which seems difficult if we couldn't even reach consensus within a group like this? Is it aiming instead for non-binding code of conduct of some sort? Maybe that would be an easier path to take. What do you think?
Institutionally, what would follow will be up to the UN General Assembly to decide. This year, there have been proposals to convene another such group. Of course, the fact that this group failed to produce a substantive report will cast a shadow on that, and some, at least, would think that there would be it would not make sense to convene another group if we are not able to agree on very fundamental points of departure for the further work. But it will be, as I said, for the states in the GA to decide. As for the issue of convention, clearly it could make sense to agree on a global convention, but then what basis do we have when states have no agreement on what to put in the convention? The approaches to the issue are really very, very different, fundamentally different. And I should perhaps mention that there was a proposal for a convention some time ago already. But the approach was a disarmament approach. The idea was to define information weapon and then create a legal regime to for the prohibition of such weapons, a kind of equivalent for the conventions that prohibit weapons of mass destruction. But that was not a very fruitful point of departure, and it has not been pursued further.
I suppose one would always have to worry as well, if you tried to do a treaty on this, that it's an area that changes so much. The capabilities change, the actors may change, that you might worry a little bit about keeping up with the technologies unless you had built into the convention some mechanism for, say, a conference of parties to convene, to develop new annexes and protocols and so on, if any such thing was needed. But it does seem to me that you're right. If this group couldn't even come to consensus on some of the broad parameters, it seems perhaps unlikely that a diplomatic conference would be able to do so. So in the absence of that, in the absence of governments stepping into this field and drawing the lines, is it possible in your mind that instead we'll see non-state actors maybe draw the lines for us? I'm thinking about academics, of course, being an academic, that's one of my favorite line drawers. But we've also got private industry as well, which is out there on a daily basis, protecting themselves from cyber attacks and so on. Is it the case that maybe there will be a code of conduct or rules of the road that you think would be developing or already are developing, perhaps through non-state conduct?
The Microsoft, of course, has presented a set of norms also for responsible state behavior. And they have been recently advocating for a Cyber Geneva Convention. So that exists. It can be seen as a useful contribution to the discussion in the same way as the various academic contributions. And relating this to what I said about our discussions last week, the academic discussion on the applicability of international law to cyber activities has, of course, for a long time already focused on exactly the issues that were a taboo for states. How to define an armed attack, how to define the threshold of the use of force, how to apply international humanitarian law to cyber activities, the use of ICTs in conflict. And I think these are very useful contributions.
And we've certainly seen areas where both government and the private sector have been able to come together to try to develop some amount of regulatory norms. I'm thinking of corporate responsibility, for example, and maybe areas of corruption and so on, that we probably should think creatively about both actors coming to the table. Let me ask you about the Tallinn manuals that were done in 2013 and I guess just published either this year or last year, the 2.0 version. They too have, there we go. Even got a demonstration. They, of course, have been dealing with some aspects of this area and have gotten a lot of attention as a group of experts convened under the auspices of the North Atlantic Treaty Organization. Is that helping us solve some of this issue? Is that a good path to go for, you know, some of the armed conflict issues? What do you think about that contribution?
It's a highly valued contribution. The 2013 Tallinn Manual, which focused exactly on jus ad bellum and jus in bello, it has made a really important contribution to the understanding of these issues. And in fact, in the absence of the absence of the international instruments in this area, and the absence of any academic contributions that would be as comprehensive, it has in a way become a leading authority in this area. It has been used as a handbook in many different countries. The new book that I just showed to you, that was launched a couple of months ago, is much broader in its focus. It covers various areas of the international law, sovereignty, jurisdiction, state responsibility, human rights, the law of the sea, space law, international telecommunications law, and so on and so forth. It's a very ambitious project. And having read the book, I must say that there's much reason to commend the quality of the experts' work also this time. But at the same time, there are inherent limitations as to what has been possible to achieve under the circumstances. And when saying under the circumstances, I'm referring particularly to the relative absence of state practice and relative absence of expressions of opinio juris by states. This is, of course, very challenging for a project that seeks to identify customary law. And this clearly is one of the ambitions of the Tailend Manual 2.0. One criticism that should not be taken as a wholesale criticism, because it's really an extremely important book, but
Go ahead. Tell us.
The experts very often, when they speak of customary law, the identification of the findings on customary law mainly rely on what the experts see as customary law, and we don't know what their methodology has been. And there we could, for instance, refer to the 2005 ICRC study on customary international humanitarian law, which was also criticized, and exactly on methodological points, even though it was based on more than 10 years of very exhaustive research conducted in more than 40 countries. Also, it was based on the ICRC's archives, which are very comprehensive. But then you can always criticize. It's easy to criticize when someone else has done the work.
Yeah, and they did a lot of work, and I suppose your point is that for the Tallinn Manual, there is relatively limited practice here.
That's
so they're
right.
not able to even rely on that amount of data that the ICRC gathered.
Exactly.
So they're relying more on their own opinion. Would you say that it's been reasonably well accepted, the Tallinn Manuals, in the Western Europe, North America, other group context, and not so much elsewhere in the world, because it is a NATO experts group? Or do you think it does have a global appeal to it, or does it just depend who you're talking to?
Both editions of the Tallinn Manual have been prepared at the invitation of the NATO CCD, COE, but they are not NATO documents. They have been prepared by independent experts, and they represent very thorough, very good, ambitious expert work. I have the impression, but this is only my educated guess or less educated guess. I have the impression that the 2013 manual has been accepted also beyond this small sphere of NATO or more broadly Western states. The new manual, of course, is too recent in order to make any assessment. And what I wanted to say earlier is that it's an essential resource for all governments, in my view, but it should not be taken as a study of customary law.
Fair enough. So let me ask you this. If it's too difficult right now for a group of experts to tackle this entire subject matter area, and way too difficult to try to do perhaps a global treaty on it, is there a possibility of identifying a particular issue of particular urgency, a more narrower slice of this perhaps, that one might try to tackle? Is it cyber actions that are engaging in economic theft, for example, or cyber actions that are dealing with efforts to attack critical infrastructure? Are there segments that maybe a group of government experts or a group of governments in a treaty context might reach consensus on, even if they can't across the board?
The treaty, in fact, has identified steps that states should take at the national level, or where they should cooperate in order, for instance, to protect critical infrastructure, or to ensure the integrity of the supply chain, or to prevent the proliferation of malicious tools and technologies. But this is done, as I said, as part of the non-binding recommendations.
Mm-hmm.
But should it be able, and this may be more for academic research for the time being, but I think what could be useful would be to go further than even the Tallinn Manual has been able to go, to identify the elements of due diligence in cyberspace. What is required of states to ensure that the territory or that the ICT infrastructure within their territory or their jurisdiction is not used in a way that violates the legal interests of other states.
Mm-hmm.
That would be one thing that could be useful. Another thing, as I said, we already mentioned the issue of political processes. It would be interesting to dwell deeper on this issue. What is interference in political processes? Does it violate the sovereignty of the target state? In which way? What are the requirements for it to? I think it's quite easy to say, in general, the requirements for it to constitute prohibited intervention in the internal affairs of states. There we have some legal criteria, but otherwise it's a bit fuzzy. It's not easy to say, for instance, whether the supposed Russian hacking in the elections in this country, how it should be legally qualified. And there have been, and referring to an interesting academic article I just read. Otherwise, but it's clearly an issue. There have been reports in different countries, the Netherlands, France, before the elections this year, from the UK before the Brexit referendum, of foreign interference. And many of us feel that something should be done about it. Legal clarity would certainly be helpful, also in this respect.
Well, I'm tempted to follow up on the Russian hacking issue, but I actually would like to follow up on something you started off with, which was the idea of due diligence by a government. And when I hear that, what I'm thinking in my mind is governments adopting national laws and regulations that would ensure that they are checking on use of the ways in which the internet is operating in their country, perhaps trying to monitor the transmission of, say, malicious software and so on. That would be the sort of due diligence to try to make sure that not only they themselves aren't doing something, but that others aren't using their territory to do things. But when we start talking about that, I can hear in the back of my mind the internet service providers of the world that are out there in the commercial realm, hosting websites and all that. Their sense that this is the government now cracking down on them, and that is a very difficult tension that would come out in the event that one tried to press hard on the due diligence side of things. Am I right in worrying a little bit about that, or am I misgauging what that might entail?
Due diligence, of course, is a standard that varies from one context to another. The Tallinn Manual, the second edition, did in fact look at the issue of how it would apply to cyberspace as a matter of law. And they came to the conclusion that there would be no duty of prevention, because that would be impossible. And that would be impossible for the state to do without violating its other international obligations, including those related to human rights.
Yeah, I can see that there'd be no duty to prevent, but still you would say best efforts to try to ensure that persons in your territory aren't engaged in unleashing malicious software and so on, that presumably requires the government to be in some fashion regulating, overseeing, monitoring, checking in this realm of rather free-flowing data and information that has a wonderful side to it, but does have a pernicious side to it. Should we be worried? Should the citizens of the world be worried about having governments too closely scrutinizing this information as it flows across the borders?
Clearly, yes. And what I am saying is that exactly for that reason, the requirements of due diligence in cyberspace should be should be clarified. There should be serious research on what that would mean in cyberspace,
which would take into account
what could reasonably be required of states.
Okay. Yeah. Well, as I think Lucinda Lowe mentioned, we have not just two members of the International Law Commission here, but we have both Claudio Grossman, a member from Chile, in the audience, and Marcelo Vasquez Bermudez, the member from Ecuador. So I can't resist asking this question, which is if maybe it's difficult to sort some of these issues out in other venues, is there a role for a body like the International Law Commission in this? A different group of experts, a group that has succeeded in some situations developing draft treaties, but also other types of instruments, and yet aren't experts in this particular area of international activity. Do you think the ILC might play a role here?
The ILC, of course, has a general mandate, so that in principle it can take up any topic of international law. And I recall that the Commission has also agreed that it should not restrict itself to traditional topics, but also look at topics that reflect new developments and the pressing needs of states, or actually the pressing needs of the community of states, something that is really touches broader interests. At the same time, as all the members all the members know, probably also all the members of the ASIL know, the Commission applies certain criteria when for the choice of topics. First, that the topic should reflect the needs of the states. Secondly, that the topic should be sufficiently advanced in terms of state practice. And thirdly, that it should be feasible and concrete. I think also in reference to what we already discussed, that the first requirement reflecting needs of states should be easily satisfied, or probably at least would be satisfied. But then the second requirement would be quite difficult. We spoke of the relative absence of reported state practice, relative absence of expressions of opinio juris by states, so that it might be difficult to find that a topic in this area would be sufficiently advanced. But this doesn't exclude certain specific topics. So I'm not saying no, but it seems to me that it would be difficult for the time being to propose something that could meet the agreement of states in the General Assembly.
Okay. Well, I know who my candidate would be for special rapporteur if we did take up that topic. But let me ask you this. You know, at times when we think about topics at the International Law Commission, we wonder, is it really an area of international law? Is it a special area of international law? And so in this particular context, cyberspace and international law, do you view it as a unique branch of international law where you do need to have state practice and maybe some treaty regimes on that? Or do you view it as simply a subject matter area where there's a whole range of international law out there, UN Charter, principles of non-intervention, and so on, that simply get applied in this particular context? Because it seems like that might dictate in part whether we should be thinking about this as a unique area that needs its own sort of set of rules, or whether we're looking at the broad rules of international law and simply applying it in this particular context.
There's very little specific regulation on cyber activities of states, apart from a few regional conventions on cybercrime and data protection, but that's all. There have been a number of comments and proposals for norms, as we already noted, but that hardly makes out an area of international law. So at best, it's an emerging area. Clearly, there are issues. Cyber raises new questions in international relations, and it certainly highlights the need for cooperation, increased cooperation by states, also with regard to malicious actions by non-state actors. But it's a very long process. And for the time being, I think it can be argued that the best strategy is to clarify existing international law instead of trying to craft new legal instruments. But I would also like to add that the development of international legal frameworks in response to technological development is not always straightforward. It may take a longer time, and it often does. If you think of the creation of a fairly comprehensive legal framework for international environmental law, it has also taken 40 or more years. The ideal certainly would be a comprehensive, preferably UN-backed convention binding on all states. As a close equivalent to this, I could mention the UN Law of the Sea Convention. It was negotiated in 8 years. It then took 14 years to enter into force, and it was based on no less than 4 existing conventions on the law of the sea, and it was based on centuries of state practice. So we are not quite there as yet with regard to cyber.
Right, fair enough. Okay, so we have about a half hour left for questions and comments from the audience, and I think there's probably a lot of thoughts everybody has had out there, whether you know something about this field or not. If it's come to your mind, then it's probably come to other people's minds. So I would encourage anyone who has a question or a comment to raise their hand, and we may have a microphone that we will send around. I don't know if that's the case, but are there any questions from the audience? Yes, ma'am, right there. Yeah, I see one up here if you want me to, it's on the ledge there. And while you maybe stand up so everybody can hear you, yeah, and tell us your name and where you're coming from and so on.
Is it on? It's on. I'm Rachel Carrillo. I'm coming from a place very far away from technology, really, but I'm from Colorado United Nations Association of Boulder County. I've been kind of wandering around DC the last month and a half. I've got kind of a twofold question, and one is I'm not sure I heard you mention, Ambassador, and thank you for being here and for your role in helping to attempt to craft something international relating to internet security. The first part of the question is, did you bring up ISOC or the Internet Society as a body, international body that is already working on global internet policies? And if not, are representatives from that body helping inform what's happening at the UN level, where you're seated with the GGE? And then the other question I have is relating to transnational organized crime, if that seems to be the overarching umbrella of internet security, whether it's electrical grid, nuclear, financial fraud, and in the case of work I've done in the past, human trafficking and the use of the internet to exploit further, but also to fight it. Could not some of these treaties or conventions that could be crafted fold into something like the Palermo Protocol, which is kind of old? I think it's from the 1990s, but it was one of the first international treaties, I think, fighting transnational organized crime. And if you could just speak to that, I'd be most grateful.
Thank you. Marja, do you want to take questions as they come, or do you want to have a few asked?
Maybe we could, if there are more questions, we could
take a few more. So others, yes, ma'am, right here in the front.
Hi, my name is Hyun Soo. I'm a student at Yale Law School. I'm just here for the summer interning at the law firm. Thank you for coming, Ambassador Lehto. My question is probably more general to international lawmaking as a whole, but I always have this concern that when it comes to state practice, there seems to be some countries whose laws and practices are viewed with less importance or even less privilege than those of other countries. And I feel like, especially in the area of cybersecurity, some countries might not have just had the opportunity to deal with these cases at all. Obviously, some countries are a lot less connected to cyberspace than some others are. So I'm wondering if that was a problem that was discussed in this working group of some countries, especially in the developing world, saying we just haven't had the chance to really deal with these issues.
Great. And maybe third one over here.
Hi, I'm Lauren Kitsis, and I'm a global data privacy manager, so I deal with the tangential but definitely related element of this. And I'm curious twofold. One, do you find it's difficult to agree on this in part because it's able to be secretive in a way that much of past militarization and combat-oriented international realm isn't? It's, you can hide a nuclear facility perhaps, but we'll find it eventually, whereas cyber elements are much trickier to track down. And related to that, since things are able to be so hidden and kind of playing off of the prior question, do you find that it's perhaps more important to bypass the need for as much of the customary international law presence so that things are safer and more countries don't go through 80 years of negotiations while succumbing to attacks and manipulation that perhaps either can't be detected or causes great harm?
Mm-hmm. Very good. Maybe we should go ahead and answer these so you don't lose track of them, and then we'll come back around. How about that? So the first question is related to ISOC and maybe the role of other non-state actors and interested in internet regulation, how they featured in the work of the group and so on.
Yes, cybersecurity can be addressed from many very different points of view. And I should have clarified that the GGE had a really very specific focus that related to international peace and security, mainly state action using ICTs and how this could threaten the maintenance of international peace and security. And for that reason, it was a very this group was a very small one. It, as mentioned, consisted only of 25 countries. Before it was 20, before that 15. And it was mainly the discussion between the main actors, the permanent members of the Security Council, and some other states that were then added to this group. We didn't use any non-governmental organizations, but we did liaise with, for instance, some of the companies, and we received contributions from different stakeholders. But the essential work was done between these 25 experts. This may seem as a very closed, very small, very unrepresentative group, but then, of course, the report, when there was a report, was submitted to the General Assembly for state consideration and also made public to anyone interested. And for instance, the 2015 report had then quite a success. It was endorsed by different fora such as G7, G20, the OSCE. So this was the relationship to outside actors. But then, as I said, our focus was really very, very limited. We didn't touch on internet governance. We didn't touch on most of the issues that come to mind when you speak of cybersecurity. It was only this limited focus on state action and whether the use of ICTs might provoke a conflict.
And what about the transnational organized crime element here? I suppose part of the focus on state action could include taking measures to stop transnational organized crime activity. It again seems to me maybe that would be an area where governments are more likely to reach consensus. Has that featured much in the discussions of the group?
Not really. It has been seen as something falling beyond the mandate. But then, if I may mention, there's one very interesting instrument in this regard prepared in the Council of Europe, the so-called Budapest Convention on cybercrime. But the convention is open to other states, non-members of the Council of Europe. And actually, it has had some success becoming more global than just a regional instrument.
The United States, I believe, is a party to the convention.
Yes,
yeah.
and I think it contains sufficient standards that could be applicable to this phenomenon.
Mm-hmm. How about the issue of lawmaking here, where some countries maybe have a privileged position because they're engaged in more of this cyberspace activity in one way or the other? Is this a problem, particularly a problem area for a global regulation, if you have a handful of countries that are at the forefront and others that aren't quite there?
I think you identified a very important problem. And certainly for those who would be looking for the creation or emergence of customary law in this area, it would be a challenge. And one reason for, and this is actually something that the CCE has done, it has encouraged states to be more transparent in relation to their ICT capabilities and in relation to their activities using ICTs.
What about the fact that so much of this is secretive? You know, it's not obvious who's doing what to whom, and therefore the dynamic with international law that often comes out, reciprocity, the ability to monitor, the ability to sanction, countermeasures, and so on. It's a little bit harder to see that operating in this realm. I mean, we have pretty good forensic ability to find out things, but that's not always true. And is that a critical problem for developing the rules in this area as compared with other areas?
Clearly, attribution remains a challenge in cyber environment. And the capabilities for attribution are not equal. These were the 2 points that came recurrently put forward in the discussions of the GTE. And actually, this was one part of the hesitation that one part of the group felt towards laying down any rules, or of course the group was not making new law, but against clearly stating any existing rules.
Mm-hmm. Mm-hmm. I mean, it is interesting how pretty much every country is vulnerable in this scenario. It's not as if there's a group of states that, you know, doesn't have to worry about this, that they have the capability to do it, but they don't have to worry about. We've clearly seen that that's not true. So you would like to think there'd be some common ground that could be reached among states wishing to fend off these kinds of attacks. And it's unfortunate that that hasn't been enough so far to allow for common ground to emerge.
I fully agree.
Okay, let's do another round here first, and then we'll come down. Yeah, gentleman in the third row, and she's about to pass you the microphone. Again, your name and...
My name's Conrad Daly, and I'm at the World Bank. I was just wondering, building off of what you just stated, the question about, if we won't go into looking at cyber warfare and cyber terrorism per se, what about the issue with stockpiling of potentially weaponizable vulnerabilities, such as in Microsoft or whatever, such as the WannaCry incident, where it directly stemmed from vulnerabilities that had been identified by the US NSA, and although a patch had been released by Microsoft, it was something that the US government had been aware of for quite some time and had kept under wraps. I understand that the US policy is to release such details to Microsoft or whomever developers so that the patches can be developed. But was this a matter, it clear that didn't happen in this incident. Was that something that was being addressed amongst your group? Thank you.
Great. And Lucinda here in the front, I think, had a question.
Yes, thank you for a very interesting discussion, Lucinda Lowe, as you know. My question really builds off the ambassador's comment a couple of moments ago about the Council of Europe's work. I found myself wondering as you went through what had been done in the UN, non-state actors, et cetera, what the potential contributions, if there's really an impasse at the UN or not, it's not right to take it forward in the UN. Is there a role for regional organizations that deal with issues of peace and security in this area? We've certainly seen in other areas, this is not an area of my expertise, but we've certainly seen in other areas that some newer issues have been able to be progressed in regional bodies, and that will later pave the way for UN initiatives to be successful after there's a certain amount of groundwork. So that's really the question.
Okay, great. I saw at least one or two other questions right there on the aisle. Yeah.
Hello, my name is Emil Losa de Siles. I'm in private practice. My firm is Names Technology and Cybersecurity Law Group. Hello, Professor Murphy. I haven't seen you in many years.
Yes,
nice
indeed.
to see you. Ambassador Lehto, thank you so much. Just a commentary, and if you have some thoughts, I'd like to hear them about, you mentioned cooperation, and you mentioned also regional cooperation. I just comment about the Organization of American States. They've been very active in the last few years. They did a very interesting study. They announced it at CSIS, where there was a comparative done on countries in the region as to their current status of cybersecurity mechanisms. And there was sort of a grading of the criteria. Very, very helpful to get an overview. And certainly the OAS has been very active in terms of capacity building, calling for public-private cooperation. So I have a question about that. And also I wondered about the new treaty that was just announced yesterday between Canada and Chile, a bilateral, China and Canada, wrong CH, about their agreement, their international convention to withhold state cyber attacks against the private sector. Might that be a narrow focus about which people can agree? Those are my thoughts.
Great. Okay, why don't we go ahead and tackle those questions, all of which are much better than the ones I asked, I must say. Starting with this idea of, stockpiling of vulnerabilities and how a government may figure out that there is a problem. They might tell a company like Microsoft, hey, you've got a problem here, develop a patch, or maybe they would hold on to it because it's valuable for them to exploit themselves. Is that something that came up in your discussions?
Actually, it did. And there were some proposals concerning non-binding guidance to states with regard to such situations. But as we didn't have a report, it didn't materialize. But I should also say that even though we didn't achieve a consensus report, we had prepared a text that to, let's say, 90% or 95% of its pages were acceptable to everyone. And I'm sure that it will be used in some way or other in the future. So this would be one problem that was identified as a problem, and some remedies were provided for that.
So hold on just a second, because this is interesting. You actually did develop 95% of what would have been a report. And it was really just 5% that held you back, or did the whole thing have issues in it that were problematic?
It's actually often so when you discuss international, whether you discuss UN General Assembly resolutions or international instruments, that the argument boils down in very small paragraphs. And in this case, maybe there are other experts in the room that may have different idea of what the percentage was, but most of the issues were not that controversial, and we had advanced during the week to narrow down the differences. Mm-hmm. But what remained controversial and was not, it was not possible to go over that was the few paragraphs relating to the application of international law.
Okay.
Unfortunately.
Okay. All right. How about the other questions, which were focused to a certain extent on the regional organizations? If this is too hard to do at the UN level, why not at the regional level? Council of Europe has done some work in this area. The OAS has been active in this area. Is that the path we should be taking for developing rules?
Actually, regional organizations have done quite a lot in this area. There's also an African Union Convention on cybercrime and data protection, although to my knowledge, it may not have entered into force as yet. The regional organizations in the Americas, in Asia, and in Europe have done a lot of work. The OSCE, for instance, has made groundbreaking work in the area of confidence building measures. And actually there has been useful interaction between the work of the GTE at the global level on confidence building measures and the work of the OSCE at the regional level. But yes, it is conceivable that regional organizations could also take the initiative of trying to find out how international law applies, but it would be preferable to do it at the global level.
Mm-hmm. And I suppose it depends what it is you're talking about. So if you had a regional treaty that required states to adopt certain types of measures to prevent persons within their territory to engage in malicious software attacks, that's great for that region, but given that the attacks may be happening globally, right, to have a fairly high level of standards in, say, Europe or a Western hemisphere, but not have those standards in other places, then that's where the attacks will originate from, perhaps, right? It's it's a problem that seems global in nature to me, that if all you can do is at the regional level, then that's what you do, and maybe that's the first step. But it doesn't sound like a long-term solution, but maybe
At least not if you speak of those very fundamental rules of international law and of the UN Charter that we were discussing in the GTE.
Mm-hmm, mm-hmm. Yeah, I should note too, just because it's come to my mind, that when there's an attack that occurs against a computer system and you don't know where it came from, it is the case now that they're beginning to develop techniques where you can send back a data stream that will find its way to where the attack originated. And in the US, I think we refer to these as NITs. What's interesting about it, though, is that you don't even know when you do that whether your NIT is going to stay within your own country or go somewhere else. And it essentially is implanting software on the device where the attack came from for the purpose of then pinging back, revealing the location. So to me, it's interesting that you don't even know necessarily it's a transnational issue when you do that. And then you don't know if it is a transnational issue, where it's going to go, what region it ends up in. So I think it just does highlight that it's a very complicated and potentially global issue, or potentially not even transnational, depending on who's engaging in the attack. Okay, maybe one more round of questions before we finish off. We'll start here in the front.
Thank you. My name is Anna Kintik, and I'm from Leiden University. And I have, I guess, a question of two portions, and it's an emerging thought, so please bear with me. But I would ask, in the context of international peace and security, how would you reconcile the lack of state practice, and then on the other hand, the suggested sense of urgency of all these issues? And then the other part of my thinking is that it is not that this conflict between freedom of information on the one hand and then state control over information on the other hand is something new. It dates back all the way since we had the UN. We've had these conversations in the context of UNESCO, ITU, now cyber in the first committee. So bring it together, well, is it urgent? Do we have time to reach consensus? And is it even an issue for states if we don't have state practice?
Great, and I think I saw Ruth Wedgwood there in the back of the room.
Well, I will just take any opportunity to, for people who are too young to know the delights of it, remember Mad Magazine with Spy versus Spy. The guy in black and the guy in white, and the guy in black was probably the virtuous one. But it was a great motif to say that everybody does it, and in fact you probably have to do it, just if only not to be vulnerable to the people who would otherwise do it, without any obstruction whatsoever. So I guess I just wondered why. I'm all for wonderful discursive ethical culture society conversations, but some of the attempts to craft things that look like rules or at least like principles may be more than we want to engage in, i.e. espionage of embassies. We hate getting broken into, but you bet your bottom dollar if you read the press, they'd probably do it too. So in this attempt to have a kind of chastity, you may be messing up things that, since they inevitably will fall into other people's hands too, may make us or our allies or helpless countries more vulnerable than they ought to be. One can be too virtuous, is my point.
And I think there's a question here in the next couple rows up. Now that Ruth has taken us to Mad Magazine, we'll see where else we go.
Nowhere is exciting. Charles Taylor from DW Law, and a couple of questions, quick ones. Follow up on that. Do we have an international convention on espionage? The answer is no.
No.
Thank you very much. And the second one is, often in an emerging sphere like this, one of the things that people who are new to the subject, there can be many people who are going to be engaged in this in developing countries and elsewhere, who have to get engaged very quickly and facing the challenge of just coming to grips with, find immensely useful is good definitions. And maybe that's the time for, or is this something that your group has looked at UN and try and define in an objective and authoritative way what we're talking about?
Any other questions? It's your last opportunity. If not, then we will go to the authoritative answers. So, question about the lack of state practice, which you talked about before, and yet the urgency in dealing with this. How do you cope with that?
You ask whether states care about this, whether it's a problem for states if we don't have state practice. Of course not. State practice is basically, it's important for the identification of customary law. But if states decide that we urgently need an international instrument concerning a certain area of cyber activities, they can go forward, and they can even task the International Law Commission to prepare draft articles, and then even the ILC could go further because it would have a clear mandate from the states to do so. It's a very specific question, and we have this question because we don't have any other way to develop law in this area for the time being. But the situation may change, and I could imagine also at the regional level that new legal instruments could be elaborated on specific issues. It's only that in the GCE we have been focusing on the basic traffic rules for international relations. And in this area, it's very difficult. There was a recent proposal on a UN convention concerning the prohibition of the use of force by ICTs. And there have been also proposals on the prohibition of the first use of force by ICTs. And there, of course, you can say that we don't need that. We have already the UN Charter, and it was already in 2005 that the UN summit of more than 160 heads of states and government confirmed that the UN Charter and its rules on the use of force apply. They are sufficient to address all kinds of threats, irrespective of the means or methods used. So maybe the discussion on the need for a cyber treaty has been too much focused on these very central issues. And maybe it could be possible in a pragmatic way to identify certain specific problems and address them by way of legal instruments.
Mm-hmm. And, to the extent that we're talking about how do you look at state practice in this area, I'm just thinking about the United States over the past year or two indicted Chinese government officials for economic espionage, indicted Russian government officials for hacking into US government databases, widespread FBI interaction with foreign government officials to track down non-state actor hacking and release of malicious software and attacks and so on. So actually, if you did a fairly thorough study of state practice, you may actually begin to find a fair amount of this going on. And this may be true, particularly as we continue forward. And when I think about state practice, it's in part active practice by a state, but it's also the response of other states. So have other states condemn the US for, say, indicting, right, Chinese government officials or so on. I mean, obviously China wasn't happy about it, but what are the reactions of other states to it?
Yes.
You might be able to piece that together in some way that helps us understand where the contours are of the rules. But that maybe leads to Ruth Wedgwood's question of, do we really want to clarify the rules? Maybe in some of these areas, but when you're talking about things like government spying on other governments, is that an area that has generally been off the table? We don't have a global convention on it. There might be some contexts where a particular convention on diplomatic properties and so on might relate to it, but generally speaking, we've hushed those things off to the side. What do you think about that? Is it fair to say, well, maybe this is an area where we just shouldn't have rules? Why should we worry about this so much?
So far, I haven't seen any real interest among states to embark on negotiating a treaty prohibiting what would be defined as illegal espionage. The situation may be changing as states get new tools and techniques to spy each other. But for the time being, I would really say that this would be a no-go at the UN.
On the espionage side of things, right?
Most likely.
Right.
Most likely.
Right. But would you still say there are other areas here that don't have to do with that? It has to do with maybe transnational organized crime, maybe
yes, clearly, yes.
uses of force, and so on, that we should be worried about. I mean, I take it that the whole idea in the group was this could lead to armed conflict. The unleashing of a malicious software that shuts down a dam in another country could result in a retaliation in the form of an armed attack, and that it would help to have it clarified. Is the opening of the dam through software, is that an armed attack that allows you to self-defend? And you should know that if you're going to unleash that software. Is that part of what we're worried about and that we're trying to deal with?
Actually, this brings us to the third question, which was about definitions.
Yeah.
There are a number of proposals for how to define an armed attack in cyberspace, but at least the group I was part of was not able to agree on such definitions. And it seems to me that we would still need more scientific academic work on this before the states would have enough material to begin to address this issue. And what we can say for the time being is what I already said, that we have the UN Charter already, we have the prohibition of the use of force. We have the rules concerning responses to armed attacks, and that should be enough. And it should be interpreted in each concrete situation. We don't have more specific rules on how this should apply to cyberspace.
Well, I'm taking that as a mandate for us academics to go forth and develop some definitions and so on to try to assist states and others in this area. Marja, this has been a great pleasure for me to have the opportunity to talk with you here in Washington, D.C. I'm very grateful that you came and spent some time here at the Tillar House, the headquarters of the American Society of International Law, and brought the expertise that you have, including just recently what's been happening in New York. It's really been a wonderful opportunity, and I'm very grateful to you. Mark Grass, the Executive Director of the American Society of International Law, is up at the podium, so I think I should throw it over to him for final words.
Great. Well, thank you very much. And I'd like, first of all, to express our appreciation to our speakers. to Ambassador Lehto for joining us here today, to Professor Murphy for conducting an expert interrogation. This was an especially rich and informative conversation on what I think we all agree is a very pressing issue. And in a moment, I'll ask you to join me in applauding the presentation. But first, a couple of announcements. I want to be sure that we express our appreciation to our colleagues at the Embassy of Finland for their co-sponsorship of this event and for working with us to make this happen. And thanks, as always, to the Tillar House staff for pulling this all together and turning out such a wonderful crowd. If you enjoyed this conversation and would like to hear more about the topic, it just so happens that on July 19th, we're going to kick off the next of our live stream discussions in our ongoing series on international law and the Trump administration with a program on international law and cyberspace. That program on the 19th is going to feature Brian Egan, the former legal advisor at the U.S. State Department, and now a partner at Steptoe & Johnson, LLP. Professor Ashley Deeks, also a former State Department official, now a professor at the University of Virginia School of Law. And to add particular interest and topicality, it will be moderated by Michael Schmidt, who, as some of you may know, is the general editor of the Tallinn Manual 2.0. So we will continue where we've left off today. If you're not a member of the Society, you are, of course, always welcome here to join us for these programs, but I'd also like to encourage you to consider becoming a member of the Society. You'll get notices of all of our events, all of our publications, and have an opportunity to participate in the work that we do here on this and many other important topics. Finally, please join us for a reception immediately outside this room following the program. Again, with thanks to the Embassy of Finland for sponsoring that reception. And finally, thank you to our speakers.